Okay, today is an important show. Tune in. I have a great guest I'll introduce in a second, but I'm Jerry Citarella. Jerry Citarella Presents, here to educate, inspire, and enlighten. And today is going to be educational for sure. And hopefully at the end of this, you're inspired to go do something. So my guest today is Richard Sprague. Richard, welcome.
Thank you.
Richard R. Sprague, attorney at law.
That's right.
Okay, so he's an attorney. I want to make sure I get it right so he doesn't sue me. No, he's a good guy. He's not that kind of attorney. He's one that's here to help you, not take you out in most cases. So Richard is here. You're here. Primarily, my interest is what you do in relationship to estate planning. And I know you do other things, and we're going to talk about that, but I know you have a unique vision of setting up estates and trusts and stuff for people because of some of your other stuff. So I want to get into all of that. Don't tune out. We're going to come right back after this intro and get into it. So here we go. Now, you do living trusts.
I do.
You do probate.
I do.
You do litigation.
Yes.
You do some advanced planning.
Yes.
Yeah. So I think what most people generally are interested in is a will or a trust, right?
Probably 90% of my estate planning clients are revocable living trust based clients.
Okay.
And part of that means that they get a living trust, a will, and powers of attorney in order to prevent any problems that happen when they become incapacitated.
Okay. Incapacitated, or make sure there's no problems that happen if they happen to pass on without those things. And we'll get into that later. That's the real scary stuff called
Probate.
probate. Yes.
Yeah.
The expensive and avoidable state fundraiser.
That's a good way to put it.
There you go.
Yeah.
Okay.
Or attorney fundraiser.
Attorney
because
fundraiser.
attorneys really win in probate.
Yeah, it's like divorce court, right?
That's
I
true.
mean, I mean, if divorced people would just realize the attorneys are the ones making all the money and the rules are already set, it'd be much better for everybody. And if people would realize that the attorneys make all the money, the state makes all the money, and there's an opportunity to avoid all that through what you do, it's so simple. And I get so many people, and this is why you're here, that just go, well, I'm not rich enough. And I want to talk about that. I don't think I have enough going on. Oh, that's way too expensive. Well, if you go to probate, it's way more expensive. And I'll say this last thing, and then it's your turn. I always tell everybody, if you think that a trust is too expensive, get your kids to pay for it. They're the ones you're going to save a ton of money, hassle, and headache. And I've had a few that have thought about that, and they've had their kids split them with them.
It's very common.
Yeah, so I love that. So tell me, who would need a trust? I'm just going to ask that as broadly as I can.
Well, currently, there are so many reasons to get a trust. Two of the primary reasons to get a trust. Number one is to avoid probate, because probate, particularly in Southern California, is extremely expensive and very time consuming. Two, trusts give you a high degree of control over the distribution of your assets during your life, but more particularly when you pass away. So if you want to control the distribution of your assets and avoid probate, then you should get a trust. But the key question as to whether you need to do that is
Right.
how much property you have, because there's thresholds right now. The threshold for probate is $208,000. If you have $208,000 worth of personal property or more, then when you pass away, all that property has to go through the probate process. Now, they just changed the law on April 1st, 2025 for real property interests, which if you have more than $700,000, $750,000 worth of real property interest, then it has to be probated when you pass away. If you have that much or less, then you don't need to go through probate. There's what we call small estate affidavit procedures or summary procedures where you can avoid probate by essentially writing out that you are the rightful heir of this property, and you get this affidavit signed and you present it to a financial institution, a bank, or even the Orange County or Los Angeles County clerk or the court, and you get this property transferred to you without probate.
Okay.
So you go to probate if you have property that exceeds that threshold.
So let me ask you a question about that. Is it the the equity in the property or the gross value of the property? So if I have a house worth $700,000 or $800,000, but I owe $700, am I exempt from that, or am I still subject to it because the value is $800?
Good question. It's gross.
Okay, so it doesn't matter how much equity I have. If my house is worth over 700 and change, whatever you said, then I'm subject to probate.
Correct.
Okay, so I'll just say this. It sounds like it's still a hassle if it's not in a trust and the trust does so many other things for you. I would still just get a trust.
It's probably a good idea just to get a trust anyways, because not only you have the probate handled if you get a trust, but there's a lot of other benefits of having a trust that are not immediately obvious to people. As a matter of fact, no one knows it except attorneys and financial planners who deal with this kind of stuff every day.
Or people that have a trust.
Or people that have trust.
And they go, I didn't know I was getting all of that.
Right.
Yeah.
And that comes with that ability to exercise the control, or exercise and control the distribution of your wealth when you pass away. If you want to make specific gifts to individuals, you need to have a trust. If you want to omit certain individuals or reduce their inheritance, you need to have a trust in order to do that. A will can do the same thing, but a will is essentially instructions to the probate court. So you have to go through probate.
It makes their job easier and they still get paid the same.
Correct.
Yeah, I love that. Also, it gives you the ability to specify. We have young kids. They're older now. They're 21, but I don't know if they're going to hate me or love me, but they get their money in certain incremental amounts over a number of years. And before they get a dime, they both have to come together and agree that they're going to give 5% of it away to some charitable organization. Our thought was, we don't want them to blow it, but we gave them enough one time that they can learn from it. And even if they end up hating each other, they're going to come together every 5 or 10 years and do something good. And then it's going to be distributed where they get the rest of it when they're age 50, but incrementally over time. That was our way of being able to distribute it to them without them blowing it all. You give a 21-year-old a decent amount of money.
Half a million,
22-year-old.
$1 million bucks.
I mean, I've had so many people say, I've inherited some money, I did it once before, and this time I'm not going to waste it all.
Right, yeah.
So that was our way. Again, forget the details. That was our way of helping the kids, controlling it, and looking past that and saying, what if they end up hating each other? Well, every 5 or 10 years they have to come together and choose a charity together to donate some of it to. We thought that was the best we can do from the grave to make them good people, keep them in touch with each other, and distribute whatever wealth we have to them in a way that they can't blow it. And you can't do that without a trust.
You cannot do that kind of high degree and specific planning without a trust. Correct. If you have a trust, there's generally two ways that you approach distributions. It's either outright, which essentially means here's the inheritance, here's the money, take it and run, do whatever you want with it. And at that point, you're giving potentially a 20 or 25-year-old $500,000, $1 million, whatever their inheritance is. But that person is subject to their own instincts, their own lack of discipline, and also their friend group, their girlfriend, their boyfriend, their spouse.
Whatever they have influencing them.
And those are the people who are usually the cause of litigation and deterioration of inheritance, are people around the beneficiaries, not necessarily the beneficiary themselves.
Gotcha.
Which is very, very common. But that's the outright distribution. The other type of distribution with trust is to hold back in trust and distribute it. You either make it according to their health, education, maintenance, and support until that trust income runs out, or you establish certain benchmarks, like they turn certain age, they get a certain portion, then 25, for instance, they get 50%, then 30, they get 50%.
Which is similar to what we did.
Okay, yeah. Or people say you get a college degree, you get a certain distribution. You graduate or finish military service.
I thought about putting something in there where they had to earn at least 10% above the national average income or something, just to make sure that they were contributing human beings to society. But I'm like, well, what if one just stays home? My wife didn't work, she raised the kids. So there would have been way too many caveats. She's way more valuable in our home than I've ever been, raising twins. So how could I discount that? And but it's kind of interesting when you think about it, and I think it's a good exercise to go through to figure out all that stuff and how you want to distribute it. So there are other things that come in the trust, right? Documents, and I call it the pull the plug document because I'm not an attorney with all the fancy words. But what else do you get typically with that package that's also important?
Well, whenever we have a revocable trust-based estate plan, you get a revocable living trust. Then you get a pour-over will, which is a special will with one distribution provision that says that anything left inside your estate goes and gets distributed according to the terms of the trust. See, oftentimes when you create a trust, you have to fund it. You have to take your property that you own, your house, your financial account, your bank account, whatever it is, and you have to transfer it to the trust and retitle it in the trust. I can't tell you how many times people create a trust.
You see my face right now.
Yeah, you see this all the time, I'm sure. And they create the trust, they go through all the headache, they pay the lawyer fees, but then they don't fund it. Or they fund it adequately and then they sell their home, get a new home, or acquire another
and don't refund it.
And don't refund it, exactly.
I get that a lot. Hey, I was referred to you. I just inherited a bunch of stuff from my parents, and I want to come in, and can you help me with it? Yeah, of course. And they bring in the trust, and they bring in the statements, and they don't match.
Nothing's in there, right.
They don't match. And the attorney set it up for them, and they paid thousands of dollars for this wonderful document that they put away, and never went to the bank, never went to the brokerage, never went to the title company, and the trust is nothing more than an instruction manual.
And when that happens and the person passes away, the pour-over will guarantees that all of the property, it's going to have to go through probate, but it's going to be a more simple probate because we know where it's going. It goes and pours over to the trust and gets owned by the trust to be distributed according to terms.
Yeah, still a process, still some costs that you can avoid. Now, I blame that on your peers partially. People have to take their own responsibility.
Go ahead.
But I have had some people that have said, well, my attorney never told me that. Okay, whatever. But I also find that more often with people that get the quotes, cheap trusts with the places that are, sometimes online or sometimes a paralegal that does it. I'm not going to say any names about, the people. But there are some people that get these less expensive documents and think they're doing something great. And those are the ones that very, very often I don't see get funded because the attorney typically doesn't help them put the property into it. And I'll ask you, that's something that's common.
100%.
So you help them put the property in and then you instruct them on what to do with the rest.
No,
A lot of them walk away with none of that and none of those instructions and they think, I got the book.
They go on LegalZoom or they go on rocketlawyer.com, and you're right. 100% of the time that I see these things, they're never funded.
Yeah.
But they get the documents. Sometimes the documents work, sometimes they don't. When they don't, they're 2, 3, 4, 5 times as expensive to fix, particularly if the person passes away and they didn't do it correctly. Then it takes way more time, way more money in order to fix it. They should have done it right the first time by hiring an attorney. But they buy these documents and they don't understand any of the concepts. They don't know what trust is. They don't know what the trustee is. They have 3 people being the trustee or co-trustees. They have no idea the implications of that inside California, which requires unanimous consent of all the trustees to take any action on the trust's behalf. So if there's a notary appointment, if there's a signing appointment, if there's a document needs to be exchanged or whatever, everyone has to be there and all the paperwork has to be signed by all 3 people. It's just completely inefficient, and you don't need it because the obligations for a trustee to act on the up and up are so tight in California. It's really hard to do right.
Okay.
To be a trustee, right, according to law. A lot of people play loosey-goosey with it. Most of the time you get away with it because a lot of families get along.
Yeah, if it's not audited and nobody complains, you get through whatever you need to get through.
Not a problem.
But
when a problem does occur,
yeah,
that's when you run into trouble.
Yeah. So I was in one situation where settling an estate, there were 4 or 5 brothers and sisters. One of them who moved closer to mom to care for her ended up stealing money from mom.
Very common scenario.
Brothers and sisters found out. It became a big deal. Mom was old at the time, didn't want to deal with it. Everybody kind of left it alone for the benefit of mom. Mom's older, early onset dementia. Mom ended up passing. Some documents were supposed to be changed. I'm now sitting in a room with all these brothers and sisters, and the trustee of the trust, the person in control of this, was the daughter that was stealing money from mom, and she's now in charge of the disposition of the trust. Yep. You want to talk about an uncomfortable meeting? So I've seen a lot of stuff where things just aren't handled and trustees shouldn't be in there, and it needs to be set up right, and I kind of want to lead into that more than anything else. Doing these right is extremely important, and I mentioned you have a view of the other side. Like you said, if they're done wrong, it's more expensive, and then dealing with probate and probate costs and litigation. So what have you seen mistakes over here that have you in a position where you can feel you can do a better job over here to avoid those mistakes? I use Waze or whatever when I drive. Why? because it can see the accident 10 miles up and it can route me around it. It's a vision that I wouldn't have just driving on my own. So what vision do you get having been on that side?
That's a great example. A perfect example to demonstrate that on the same vein would be having co-trustees. Okay. The reason you do not have co-trustees is not only the logistical problems I was discussing earlier, where you need two people to approve every single action taken on behalf of the trust, but also if you have two co-trustees, trustees are represented by counsel.
Okay.
All right. So when people set up their trust and they're the trustee during their life and they're the primary beneficiary, then they pass away. The successor trustee takes over and starts managing the trust according to the terms, and they do whatever the trust terms say. If there's two trustees and they're co-trustees, they get represented by lawyers in order to do whatever the trust says. We change title on property, we do accountings for all the beneficiaries, we make sure if there's any litigation, we handle that. Well, most estate planners don't. I do,
Okay.
which gives me that kind of
The edge.
the edge.
The edge, yeah.
I've seen these things happen, and so I know why we do them in the
Yeah.
planning phase.
Yeah.
Well, a great case in point is I had a client who was a planning client. She passed away, but she had a split inside of her family, and that split had gotten healed up. Decades later, we're talking about over 50 years, there were a lot of difficult problems the family was having. Well, part of the healing process, when she was making her estate plan, she thought that part of that healing process would to take two of the ringleaders, let's call it, two of the leaders of the conflict, two conflicting siblings, and make them co-trustees.
Awesome.
Because everyone was getting together and feeling high and feeling great, and so let's make them manage it
Yeah.
together. Oh, great, what a great moment.
Yeah.
All right,
Let's put-
everyone's happy.
Let's put two angry pit bulls in a ring.
That's exactly what happened when the client passed away, and that mantle of trusteeship that successor trustees took over, co-trustees, I was representing both of them. They started disagreeing over what to do with the house, how much to sell it for, who to sell it to. Shouldn't we just rent it and keep it as an investment property so we can get the income? No, we should just sell it. Oh, but if we're going to sell it, we should fix it up. No, we should sell it. We should just do a cash offer right now. I know a guy right now. That guy's your friend. You're just doing this for your... You see what I mean?
I've seen all of it. Yeah.
Okay, so they start fighting.
It's so real.
And because I'm representing both of them, they're both my clients. And we have a duty to zealously represent our client's interests. We have to be loyal to our client. We can't advocate for our interests. We can't advocate for a third party's interests. We have to advocate for our client's interest.
Right.
Well, if we're representing two different clients and their interests are diametrically opposed, I'm conflicted out.
Yeah.
So I have to back out. Now I can't represent either of them. I have to send a letter and say, okay, I can't represent both of you guys because you're disputing over this. You have to hire separate counsel. And so now both of them have to hire other attorneys. You go outside the marketplace and you look for another attorney. It's not going to take long to find someone who will advocate on your behalf because you're going to be paying them.
Yeah.
And so a lawyer's interest, particularly litigators, and I'm sorry to say this, a lot of good litigators out there, but it's not difficult to find someone who will pick a fight to get paid a lawyer's wage.
Yes. That's a whole other show. I'm very familiar with that process. I've seen that in divorces. I've seen it in other things, 100%. So great advice. Worst situation I've seen. I can tell a bunch of stories here. And I think these stories are important. We can go through the technicalities of it, but I think the stories actually tell more about the need for it. He knows what he's doing. So I had a family, a client of mine, husband and wife, dad dies, no trust. Company is worth about $15 million. There's a farm, there's a property, there's a bunch of stuff. The one brother of three was closer to it, worked in the company a little bit, said, nope, dad was failing a little bit. I'm going to rescue the company. We're going to sell it. On and on and on and on. Long story short, mom ended up dying of stress because her babies were all fighting and suing each other. Okay, this is a multi-year process to get to this point. Mom dies. Now, when they confirm she died of stress, no, but she was fine before, and she died while they were going through this. Kids were all suing each other. Ended up out of the $15, $18, $20 million estate, each of them ended up with, I think it was at or around $1 million after all was said and done, and it got depleted and lawyers got all of theirs. My client's wife, who was fed up with this, said, I'm going to send you to this therapy or a retreat. You need to. While he was gone, she left the house, cleaned out the bank account, sold all the furniture, and started her own life because she was done, because she'd been telling him for years. So if they had a trust, if dad had set some things up, if things were organized properly prior, the kids would have ended up. But like you said, you get decision makers that have different ideas and different objectives. And I was dealing with it recently. Two brothers inherited a house. Exactly what you said. One wanted to sell it, coincidentally, to a friend. The other one thought they should fix it up. The other one didn't want to put money in because there wasn't enough available, And what ended up happening, that was on the market for whatever. Long story short, again, it didn't work out. So I truly, truly appreciate what you do, and I hope people watching understand the benefit of it. Is there any other? The probate stuff is something nobody wants to do, but if anybody's watching this and you're in a situation where probate, I just want to mention you do that as well. People can hear that you're obviously credible. The litigation side of it is, what do you typically litigate, just so we can get everything out there that you do?
What I do is I do planning, I do administration. Administration is doing what a trust says to do when the time to do it arrives. Distributing the property, making distributions and all that, so forth. Then also probate administration, so I do the probate process, and I do litigation and appeals. And litigation, I do a lot of estate litigation. Estate litigation involves challenges to trust instruments, whether you're challenging a trust instrument based off undue influence or incapacity or fraud or mistake. Essentially, when someone cuts out, probably the most common instance of litigation is when a step-parent cuts out a step-sibling. Or sorry, a
Stepchild.
Stepchild, thank you.
Gotcha.
That's probably mixed families or families with stepchildren, blended families.
Blended families.
Blended families, thank you.
Yeah.
Blended families are the most common
Brady
source
Bunch
of litigation, period.
Gotcha.
For cutting out someone. Also, whenever a trustee is not doing their job, they're not providing reasonable access to information, they're not providing accountings, they're paying themselves too much, they're making bad decisions on trust property, like letting it sit there, not earn money. Like I said, it's very difficult to be a trustee properly, according to the law. It's very difficult to do it right.
Yeah.
It's just most of the time you don't hear about this or you get by because families get along and everything goes smoothly, so there's no
And that does happen. That does happen a lot.
Yeah, most of the time, it's smoothly.
And I've been asked to be a trustee numbers of times. Good news is I can't do it for my clients. There's laws against it and other things. But even people that aren't clients that ask me to do it because they know my position, they know I understand them, I just tell them I can't by law because I want no part of it.
Good decision.
Yeah, but I do know. I also been asked to be a guardian for people's children. I'll do it, but there's a caveat. We need to make sure that the trust is in place. We need to make sure there's life insurance in place, not because I want anything. I want to make sure your child can have. So there's always planning that can be done in advance that fixes a problem that could potentially come. It's an insurance policy, if you will, and everybody hates paying insurance, but the good thing about a trust is it's a one-time payment. Okay,
that's right.
And we're not going to get into pricing here, but I just want to say to your face, thank you for your pricing. You're extremely fair in a market where I know you could charge more, and I just appreciate that. And hopefully you don't go out and raise your prices now, but I'm not saying you're the cheapest in town because you don't want that, but I know the market, you know the market, and you put yourself in a place with the level of expertise and experience you have where I know you could charge a bit more for that service, but you've made it attainable for a lot of people that otherwise might back out because of the cost. And I truly appreciate that, so thank you.
Thank you for saying that.
Yeah, no, just truth.
My pleasure.
That's not here. My book was called The Truth Helps. Everything was The Truth Helps. You'll never hear anything out of my mouth that I don't mean, and I mean it. So last question is larger estates. I know we were discussing this earlier, and I jokingly said I forgot the number because it got so high. So there's something called the estate tax, and a lot of people think that a trust will help you avoid what people typically call the inheritance tax, and there's really no such thing. The inheritance tax can be misconstrued as probate cost, or it can be estate tax. If you have stocks and if you have stocks or real estate, currently there's a step up in cost basis and there's no income tax. So a lot of the estate can pass naturally with no tax, but there is probate cost if you don't have a trust. But then on the other side of it, there's something called estate tax. And you and I probably both remember when that was, what, 600 and something thousand per person?
1999?
That you can die with without that estate tax.
That's
and if you do a proper trust with an AB provision, which, whatever it's called, you can avoid that. And then that went up and up and up, and now it's a big number, which is how much?
It's 15 million presently.
Okay. So
with the big beautiful bill, it became 15 million permanently.
Oh, okay, that's what I want to talk about. So you and I right now, if we were married, and that is legal if we wanted to.
That's true.
If we died,
we each have,
and we had $30 million that we were passing along, and we did a properly set up trust, our children, our heirs, could inherit that with no additional estate tax. If it goes above that, then it goes into that world. So single, 15 million. Together, properly set up trust, 30 million. And now you said it's permanent. I mean, permanent forever, or is it 5 years or 7 years or 10 years?
well, when it was
going to sunset, and it was all this, yeah.
correct. When it was 675,000, Obama raised it to 5 million, the exemption permanently. And just to give a little background, estate tax is a tax on the value of your estate when you pass away. So when you pass away, the IRS asks you to take all of your assets, your jointly held properties, your real properties, your finances, your cash, your properties in revocable living trusts, your insurance, all this stuff.
Retirement
you add
plans.
it all up, retirement plans, everything. You add it all up, and if it exceeds the exemption, it gets taxed at 40% for every dollar that it exceeds. Right.
And it could be double tax. If it's a retirement plan and you inherit it, you're paying income tax as that money comes out, and you're also paying income tax. So there's some, or state tax. So there's some important planning that needs to happen.
Correct. Yes.
If you're in a high tax bracket and you inherit $1 million IRA, it can end up being a, I don't know, $200,000 IRA in the end.
That's right. Yeah, you're right. Absolutely.
And you have to pay that estate tax within a certain amount of time. Well, or there's other problems, which means that's what the quote unquote fire sale comes in, because people start selling assets at a discount because they don't have the money to pay the tax.
Right. It's particularly felt in small businesses where the most of your money and your equity or value is in a small business. If it exceeds the exemption, what do?
Right.
You have to sell your business. Well, what do? You have to try and raise capital as quick as possible.
Right.
But when you figure out what the value of your gross estate is, every dollar, it's taxed at 40% beyond the exemption. In around 2000, it was 675,000 was the exemption. Obama raised it permanently to 5 million. So you had to have more than $5 million to face an estate tax issue. Trump doubled it when he got in office the first time to 10 million, and with the passage of the big beautiful bill, so-called, now it's 15 million a person.
Okay.
So you have to have more than that
So
get tax. But the permanent side of it,
yeah, it's permanent.
remember, Obama raised it permanently to 5.
Yes, so it's permanently until changed again.
Correct.
Okay, that's what I wanted to
That's
touch
what
on.
permanent means until they decide they want to change
Yeah,
it.
so it's a $30 million estate that can be easily avoid any estate tax with your help. If you go above that, it's a big tax, but there's other solutions to help offset that or pay for it.
Oh, absolutely.
So, yeah, so if you're in a small estate situation, typical family, I got a couple kids, I got a house, I have a 401k, I got some stuff, all totaled, maybe the gross value of everything is $1.5 million. I would say 100% you still need a living trust, especially when you have children to control the distribution and other things, the durable powers of attorney and everything else. So I don't think, and you correct me if I'm wrong, I don't think there's a number, and this is what I always get, well, how much do I have to have? I don't think there's a number that justifies the need for let's call it a basic living trust. I just think there's a desire to have some control of the assets after you're gone and make sure there's no problems. If I have these 2 coffee cups and I want to make sure each kid gets one, the only way I can do that for sure is set up a trust that says Johnny gets this one and Jill gets this one. Otherwise, it is a fight. Whether they just go into the house and start fighting over the stuff or whether they go to court and fight, it's a fight. So I think, my opinion, there is no number, and it's a lot lower. I think that would be justifiable than a lot of people think. Is that fair to say?
Yeah, that's fair.
Okay.
The control over your wealth and your legacy, which you worked your entire life to build and you want to pass on to your children the way you want to, is enough reason to get a revocable living trust.
Gotcha.
Regardless of the value.
Okay. So we can go on and on and on and on and on. And we touched on a couple areas that we can really drill down into, and it's fun. We're nerdy this way.
Guilty.
Guilty. But what I want to do is end it so, we're not the cure for insomnia at this point. People are watching us as they fall asleep. We want to keep them interested. But I know you're doing a whole series of deeper dive educational stuff, very topical, on your website. So we're going to put that up here, but if you can look into this camera here and just kind of say your website and maybe some of the topics you're going to be discussing, we'll hopefully have people go watch over at your website where there's more detail.
Yeah, it's www.rsprague.com. That's RSPRAGUE law.com. My name's Richard Sprague. You can Google me and find my website. I am building a very large informational and educational resource on all things estate planning, whether it comes to trusts, wills, and probate, to litigation, and even appeals, so that the general public can have more access to information about how this stuff works and that you can better plan for your own legacy.
Awesome. So my promise to the people that watch this is anybody who comes on the show is going to be qualified, tested. I just want you to know that I take this very seriously, and I know a lot of attorneys, and I really appreciate you being on. Since I've moved here to this area, I've spoken to 3 or 4 others. Haven't invited any to be on the show. Not that they're not good. I just was looking for the right person with the right heart, which is a big part of it. Not to say that a lot of attorneys don't have hearts. What's funny? I think most of the attorneys I've met that get into estate planning are actually really
good people.
Yeah. Not to say that other attorneys aren't good people, but it's a different mindset. So I do notice there is some consistency in that. But again, I know we met recently, full disclosure, but I've been doing this a very, very long time, and I kind of know what to look for. And I do appreciate you being on, and I appreciate your honesty and your integrity and your abilities. And I really love the fact that you've been through probate a number of times to be able to help people up front. You've seen that accident up ahead and know how to avoid it. So if there's anything you'd like to end with it. If we just want to end, I'll wrap it up. What are your thoughts?
Oh, that's good. Well, thank you very much for your kind words and for having me on, Gary. I appreciate it.
And definitely get on and check out his website. There's going to be a whole bunch of stuff, bunch of topical that may affect a lot of you, may affect some of you, but if you look on there, especially if you have something very, very specific. I was mentioning to you, I'm dealing with a situation right now. It's a CEO of a pretty big company that's getting an interesting payment in an interesting way that's very, very highly taxable. And you and I kind of went back and forth a little bit. It's a very unique situation that some trusts that are more advanced may be able to help with. So you never know. If there's a problem you have, go on Richard's site, take a look around. And Richard, I appreciate you being here, and maybe we'll do another one and dive a little deeper into some areas we think are important. But inspired, hopefully, enlightened, hopefully, educated, definitely. Jerry Citarella Presents, giving you some good information. Hopefully, share, like, subscribe, all those good things. Tell all your friends about us, and come back again soon, because we're getting more and more consistent with the good information, and I have some really cool guests coming soon. Thanks for being here, and I'll see you soon.